Thank you for joining us. This is Dr. Deborah Dupree, the Mindset Doc, and we're here today with Felicia Menta on our monthly Q&A, what to do with medical factors in the workplace. Welcome, Felicia.
Welcome, Deborah. It's nice to be here.
Thank you. Thank you. I'm so excited, Felicia, as we plan for each monthly session, I sometimes say, it's going to slow down. It's going to slow down. But, the topics keep evolving. And so I'm really excited about today's topics. And so let me share with our viewers and listeners what we're going to cover so they can sort of follow along. First, exposing the new EEOC guidance on COVID-related testing. Some change is happening, and so we need to know and understand just what does that mean. Secondly, complex case factors, how to navigate through the muddy waters. And I think we probably everybody on this call, can recall actual situations of where, oh my gosh, this is complicated, this is complex. And I know for those of you who've been with me in a session, I will talk about the two key laws that drive us into the process, but bring in the other ones as things happen, but then also changing circumstances. And so how do we do that? And then lastly, when emotions run high, managing challenging confrontations during crucial conversations. And so with that, I'm really, delighted to launch. I do want to just make an acknowledgement, and I'll do so at the end, is that we are going to go dark in December. So join us back in January, that third Monday of the month. But we thought it'd be a great time for everyone to be able to spend time uninterrupted and to have that quality time with family. And I know it'll be busy as we wrap up our work schedule and move into the holidays. And so we will see you back in January. So watch for your emails, watch for the notices. But let's get going for today, November 21st. Great. Okay. So closing the new EEOC guidance. And I'm going to put a link into the chat box because there's an excellent article about this. Felicia's going to help us sort of digest just what does this mean? What's going on?
Well, as you know, Deborah, everything's been evolving and changing as we've been going along with respect to EEOC and ADA and COVID-related matters. What I thought I would revisit is on July 12th, the EEOC issued some updates in their guidance across several different areas relating to COVID-19 and the workplace, including when employees can be required to undergo COVID-19 testing, some guidance, reasonable accommodations specific to COVID-19, and parameters around employers and some of our school districts that have mandatory vaccination programs. So specifically with regard to the COVID-19 screening tests in the workplace, to go back before the new guidance, the EEOC's prior guidance stated that conducting mandatory worksite COVID-19 testing always met with the ADA standard, then any mandatory medical tests be job-related and consistent with business necessity. The new guidance changes that a little bit and says that going forward, COVID-19 workplace testing is no longer automatically compliant with the ADA standard, and instead, employers will need to assess whether testing is job-related and consistent with their business necessity based on the pandemic at the time and on individual workplace circumstances. So the EEOC went a little further, and they did identify several possible considerations that employers can use, such as the level of community transmission that's going on, what types of contacts employees may have with others in the workplace, like we do with students and coworkers in our school environment, or if they're working with medically vulnerable individuals. And then obviously the vaccination status of the individuals or the employees, and the degree to which breakthrough infections are possible for their employees. And then the ease of transmissibility of the current variant, which we know is really easy to transfer, and the accuracy and speed of processing for different types of COVID-19 viral tests. And obviously they're talking about the rapid tests or the at-home tests. And the potential impact, I think for you and I, the most important feature, or one of them here, is the potential impact on operations if an employee enters the workplace with COVID-19, because we have children and we have other staff to consider. Not all our employees are working in an isolated workspace, right? So then the updated guidance further stated that mandatory COVID-19 testing will meet the business necessity standard when it's consistent with the CDC, the FDA, and local public health authorities. But it did add that all of these authorities revised their guidance on a regular basis, right? So it was saying that you need to take in effect new information and changing conditions. So, and then the updates additionally clarified that this analysis only applies to COVID-19 viral testing, not to antibody testing.
Right.
That is not included in this. It didn't change. Interestingly enough, the EEOC guidance did not change regarding the other COVID-19 screening methods, meaning you can still ask employees who are physically entering a workplace if they've tested positive for COVID or if they have symptoms associated with COVID, similar to when you walk into a Kaiser or you walk into any care facility, first thing they ask you, right? And that you may exclude individuals from entering your workplace based on answers to those questions, right? Mm-hmm. That still is in effect. They did not change that.
So and let me just interject there for two reasons. Then, so it's still permissible to ask those questions about a health condition, which normally, we don't ask those kinds of questions. But under COVID, it's still okay. I want everyone to hear that it's still okay, at least for now, to ask those questions. The other thing I think I'd like to just amplify, because I'm glad you brought that out, as far as the ongoing testing applies to viral testing, but not the antibody testing. And the reason why is that antibody testing only demonstrates, do you have antibodies, but it doesn't let you know if somebody has been infected or is infected right now. And so that's another kind of thing that's evolved over time. And so one will prove the existence of an infection, or so we think, and while the other one does not prove infection, it just says you've had COVID in the past.
Right. I wanted to add too, that what also remains unchanged is if an employer wants to ask an individual employee, as opposed to general screening entering the workplace, questions regarding symptoms associated with COVID, the employer must have a reasonable belief based on objective evidence that the individual may have COVID-19. Mm-hmm. And they also included new guidance regarding the screenings, because this can occur during the new hire process.
Yeah.
If an employer screens everyone for COVID-19 before permitting entry to the work site, such as visitors, contractors, etc., they can screen new job applicants as well. So there's a lot to unpack in that article. Obviously, I didn't want to take up all of our time going over that, but it talks about when you can withdraw job offers, and it also does talk about the impact on the reasonable accommodation process, which I thought for here, the new guidance includes a statement that some of the pandemic created issues resulted in some justifiable delays in the interactive process or providing reasonable accommodation. And they're saying that cover may no longer exist. Yeah. They're saying that new issues could have arisen that impact timing. And we see those a lot, right? With either the employee failing to cooperate, or an employee is not working right then, or their illness prevents them from coming in and meeting. And, you can work with that in a number of different ways. But if a delay occurs with holding the IPM or scheduling the IPM, the employer must show specific pandemic-related circumstances that justify a delay in providing the reasonable accommodation. So there is a lot of, even though this updated guidance was in July, there was so much going on and so much coming out. I think it's good to revisit all of the areas that it talks about.
Yeah. Well, on that note too, I think it's certainly seen this before too, but I know we're going to talk more about, continuing to do IPMs virtually. I think I may have said before, and as I know in my broader mediation circles, we learned very quickly after the onset of COVID that the virtual mediation process was highly successful. In some of these delays about being exposed to COVID and things like that, is taken away when you can meet virtually. And, and particularly since, the severity of having COVID is not as great as it used to be, that again, there's no reason why we can't continue to meet, because the employee is still being paid. And so since we're not asking them to travel and they're engaging virtually, there's no risk to anybody. But then that helps the employer avoid unnecessary delays. Let's face it, we all know that there are people who have used, I have COVID again. I have COVID again, and that has caused delays. And so just encourage people to continue thinking, hey, this is an employee in the workplace. This is an hour and a half meeting, and again, we can get so much accomplished in the virtual setting.
I think everything that we can do to demystify and educate about the meeting. I see a lot of resistance around scheduling the meeting, having the meeting with employees. And I don't know if that comes from their union reps or from their attorneys, whereas I think it's so helpful, to get together and talk about everything. But you're right, a lot of the employers have been meeting with quite a bit of resistance, right? Especially saying, well, I'm not working, so I don't have to come in and do an IPM meeting because I'm out on, whether it's work comp leave or whether they're out on sick leave, they're still employees of the district and they still need to engage and talk about their work issues.
Absolutely. Yes. Yeah. And I think, when we had our JPA training conference, a few weeks ago, that, what we saw was that, particularly on the workers' comp side, is just because school's out, that the delays in not meeting timely can cost an employer $6,000, as opposed to, calling somebody in, we need to have this meeting. It's a condition of employment, and that, we'll pay you to be there. That's a heck of a lot less costly than having that $6,000 imposed on you for the job retraining voucher when you don't meet in a timely and good faith effort. And I think one of the things, and I know we're going to talk about this in a little bit too with one of the other topics here today, and we're seeing this in the broader mediation or dispute resolution field as well, but changing some of our lingo and making sure that, for example, one of the things that we're doing in the legal mediator arena is trying to make sure that we're not using combative terms from court in the mediation room, because it's two different processes. And so we can actually create opposition when it's unnecessary. And so one of the things I know you've heard me say, and I imagine others have too, is that it's the conversation. It's conversation about an employee and employer in a confidential setting facilitated by a third party neutral to explore. By law, you've got a medical condition. We need to talk about that. And by law, employer, you need to find out, how do we help this person be at work, stay at work, and perform the work? And so it's a conversation and not a confrontation. And so if we can use that kind of verbiage and mindset as we approach employees about, and this is where you and I've talked about many times and continue to advocate that employers take a look at the tone and the language used in their letters of notification. And I know that's where I've tried to work with many, many employers as far as let's change, what this intent, because it's not punitive, it's not disciplinary. And yet I think sometimes those letters come out so harsh, quite honestly, that it's scary. It's scary. Right. People are already scared because they have a medical condition they may not know the direction of. And so they do fear losing their employment. So we need to dispel those myths about that.
Right. And it is a fine line to walk, because you do have to communicate when leave is running out and when you might, be running through things or the end of your last day in paid status. These are facts, right? But I think the letter and the education around those things is what we can work on demystifying and softening and, using our real compassionate language, right?
Yeah. Because by taking, and I've learned this through my many years of being a mediator, is by it may not come so naturally to some school districts or leaders, but the more we employ that more compassionate approach, and really it's about working together, collaborating together, not against each other, is that will reduce your potential for litigation. Okay.
I wish we could change our letters in workers' comp. They have a lot of legalese and they're horrible, but because they're state mandated and the language is state mandated, we cannot really change the letters. What we try to do, the claims team and I, is educate and demystify on the phone and with all of our other communication that's not in the state mandated work comp letters, which are so legally hard to understand and intimidating, frankly.
Oh, they've been that way since I started in the workers' comp field back in the early 80s, so and so to recognize for employers what they can change and where they cannot, because like you said, those things are legally mandated under workers' comp, but the employer can take responsibility and shift that direction, recognizing what's coming from workers' comp versus what's coming from the district's office.
And that's how I think that the appointment letter is very important, and all of the emails around setting the appointment, and that you can bring people with you. This makes it, less intimidating, and a little more explanation, and maybe including a link to your web video on the process. So, because I do fear that some people just think, oh, this is a meeting, I'm going to lose my job.
Right.
That's the short. They pass everything else they've heard. This is the meeting, I'm going to lose my job. Right.
Yeah. Well, and one of the things, and I know, again, it's in the law, Americans with Disabilities Act. Well, back in 1990, when that was passed, that made sense, because the market that was really being targeted by the ADA were those people who had significant visible physical disabilities, that, because of employer bias, truly did limit and bar them from employment. Well, things have changed, again, it's really about medical conditions, because there are so many medical conditions that can impact our ability to be at work, stay at work, and perform the work that aren't really disabilities. And so again, it's a mindset shift. And so that's why, when you hear me speak or any letters I help employers write, I take the word disability out and then
Mhm.
talk about medical conditions, because in that regard, we all have them.
Mhm.
We
I
all
would
have them.
say that the majority of our work comp claims are not things you could readily see, that are not apparent just by
Exactly.
watching the person walk or looking at them at work. You wouldn't actually know that they had a work comp injury and what it was. You might not
Right.
be able to tell.
Yeah. Yeah. And that's why, we talk about the hidden disabilities then. Yeah. So, I want to move on to, one of the things we've talked about before, but complex case factors and how to navigate through the muddy waters. And one of the things we talked about, I think it was at our last Q&A, was about the fitness for duty exams. And I know I've had a few cases come up. It's keeping me quite busy right now, getting those set up.
Mhm.
And I think to illustrate this, there's another link that we provided. And again, the link is in the chat box, and I'll put this one in too, but also we'll provide it with the follow-up recording. But yeah, there's really clear-cut guidance being put out there now about employers' use of fitness for duty examinations. And so, in fact, there's a great training program coming up on December 14th. That again will be in the link so that you have an opportunity to get the information firsthand. But I guess from your perspective, Felicia, what might be an example of how you've seen the fitness for duty used?
We've had a few cases that you're aware of too, where unfortunately in the work comp system, we allow multiple physicians to make determinations. And the primary treating physician can make a determination. And a lot of times they'll really have a close working relationship with the employee, and they'll release them to full duty with no permanent work restrictions. And then they'll have a second opinion later with a QME or an AME, and they'll determine that no, they have this much permanent disability and they have permanent work restrictions. And sometimes that employee is already working back to work, full duty, and then comes along this second opinion. And which in work comp world, the examiners look at that opinion as higher. But as we know in ADA, we just look at everything, right? It all comes in on the table. And then we have a conflict. And then we can go back to the treater and send them the QME, the work comp claims team can go back to the treater and send him the QME and say, hey, do you agree? But what happens if he says, no, I don't agree. I think he can go to work. Then we have a real problem. And so in workers' comp, they can resolve that. They can split the difference between the two reports. They can kind of navigate the permanent disability and future medical care. It's impossible to split. You can work full duty, or no, you can't. And you need to have the following limitations placed on you permanently. Those two things just don't jive. And we try to resolve it in the comp system. But if we cannot, I think a fit for duty is a good way. We've even seen, we have another case that's kind of like that, where there's a return to work. There's one with these work restrictions and there's a QME with these work restrictions. And one's more restrictive than the other. And we generally tell them, use the one that's most restrictive, be the most careful, right? But then the employee brought in the day before the IPM from his private physician, full release.
Yeah.
I have no disability. I have no restrictions, no limitations. I can do this job fully. And in work comp, we don't even know who that is.
Yeah.
Right.
Yeah.
And we can't know because that's HIPAA protected. And then, the employer said, what do we do now? Like, what are we now supposed to do? And I think that a fit for duty can provide clarity in that situation, because sometimes you can't go back to the personal physician and ask them any questions. And we're not going to send them the work comp reporting and ask them what they think, So sometimes it's hard to clarify the record. You and I always say we should meet to talk about the conflicts and the contradictory evidence that we're placed with, because maybe the employee has some comments that could help about this. And then we have to figure out a solution. In work comp, they don't have to figure out a solution. They're going to, like what we call Solomon of old. We're going to split it, right? And try to we're going to compromise and work something out. But when you have two, we need to really actually have some real advice on what is safe and what can they do at work. And if we can't get clarity, a fit for duty is not the only way, but it is a legitimate way. It's not an inexpensive way. It isn't. It's not and what I tell the districts, that doesn't live, that never goes into the work comp file. They don't see that report. We're not going to consider that report. That report is not going to be part of the settlement. It lives outside. It's paid for by the employer. It's done by the employer to try to get clarity, because you wouldn't think clarity would be so difficult in returning somebody to work, but it is, because there are subjective factors involved, and the relationships between different kinds of doctors. A QME and an AME sees an employee one time. That's it. And their relationship is very forensic. It's very factual. It's very, let me look at the book and rate you. Let me measure your knee. Let me look at your back surgery. A personal physician doesn't do that. And a treating physician knows you in a whole different capacity.
Right.
They might have seen you every month for a year or more.
Right.
And they want to help you. And if you're going to lose your job, they'll try to help you.
Yeah.
So it just is, right? It's not as black and white as what people would think, that all doctors have the same opinions about the same issues. They just don't. Some
excellent points there. And I'd like to add to that too, in that the workers' compensation system exists, and for good reasons. What I think you and I both have seen, though, many times over the years that we've known each other, which goes back many, is that employers will oftentimes use the workers' comp system as their guide, and Bibles always say for the return to work process. And that is very important to consider all that, but that can't be the end all, because we have these different laws like the Americans with Disabilities Act, the California Fair Employment Housing Act, and so on. And I see too many employers wait until that final MMI comes in to even have a conversation. And by that time, benefits are out, the 100 days are up. And I know I did one just recently. It's like, well, here's the rock in the hard place, is that we understand that your treatment, your recovery has taken so much longer. But the reality is we have these other laws that only provide so many days of benefits, and we're simply up against the wall, And so I know in that case, I said, from my perspective and having worked with all these things, what I would encourage you to think about. The employer was on board, but the employee's like, the best and easiest, fastest way to reach resolution about your return to workability is to do a fitness for duty, because his own treating doctor in workers' comp had already taken him off the job where there was no lifting, there was no above shoulder reaching. It was like, and he even got hurt on the job. So it's like, oh, but this is somebody who had a history of not being able to do the original job he was hired for, and because of performance issues, got moved to something else that was less demanding, still wasn't performing to the way he was. He was put into an extremely light position, necessary, a real job. And then that's where he got injured. And so we have like 3 or 4 years of chronic poor performance. And now we're dealing with, he's got a work-related injury. And so he's claiming he can't do all these things. His treating doctor supporting it, but it's like, this is probably the lightest job you could possibly do. And so that's actually happening tomorrow, and so we hope to get clarity. We hope to bring resolution to this. And that sort of gets into our other topic we're going to get into as well. But yeah, fitness for duty can be very, very clarifying.
And I think that more information is more. And so in my perfect world, in workers' comp, what we're required to do day one, when you get hurt, we have to send you what we call a start letter. And it's a start of your disability. And in that letter, we say, you're disabled starting this day. You're going to be receiving this much a week. It's going to be passed along in your employer's payroll in our system, because we do salary continuation because of the 60 days of IA leave. We don't talk about the IA leave because that's an ed code benefit. Work comp doesn't talk about that. We talk about how it's going to be paid. And then we talk about what your options are if you disagree with the amount or if you have any questions. And then we talk about that it ends in 104 weeks, that's the maximum amount. So we set the parameters from the beginning. In my perfect world, the employers would sit down at the beginning and do a start. We're going to start your 60 days of IA leave. It's going to start this day. It's going to be this much money. This is including your workers' comp. It's going to end on this day. Then we're going to start using your sick leave, and it's going to go on like this until it runs out, and this will be approximately here. And so there is some understanding in the beginning of the clock. So in workers' comp, we set the clock from day one. 104 weeks is the clock. That's the end. But we don't do that on the employer side very often. I don't see clarity around that. And it creates a lot of misunderstandings, because I have a lot of conversations with union reps and applicants' attorneys, honestly, that also don't understand our system.
Right.
Everything runs out. Sick leave runs out and IA leave runs out. I've heard so many times over my 15 years in this job, employees telling me, no, I got hurt at the work. I'm going to get my full salary for as long as I'm disabled, however long that is. There's a real disconnect between, because that's not how anything works, right? You're just off forever and you get your full pay forever. But a lot of employees do think that is what they think.
Yeah. Well, and those are some of the changes that I know both you and I have seen in workers' comp. The workers' comp benefit was very rich, back in the 80s and early 90s. And then there were major legislative changes that brought a change to how workers' comp was being implemented. And even again, more, changes are because the leave did, or the benefits did go on for a long, long time.
Yes.
And there was a lack of control, and it was like, oh my gosh, but yeah, so the 104 weeks is a newer element when I think about our 30 plus years in workers' comp. That's different than what it used to be.
Yes.
And so that's why it's so important to stay on top of this. But I love your idea about employers looking at doing a start letter like they do in workers' comp. So that a roadmap is laid out. And I actually know I have developed some flow charts to help people with that and share it whenever I'm asked to come in with an IPM. But I think that would be an excellent thing for employers to consider doing, just like we talk about softening their language in their letters, is that there's got to be a management process of this. And I know some of my training in the past has talked about, somebody's off. Well, when I set up programs for employers, it was like someone's off 2 weeks. First notice, get the job description to the doctor, let them know that you have an active return to work program while someone's recovering, and that 90 days actually have the first IPM. Here's where this could go. We want to coordinate together, and we may not have to meet again for quite a while, but there was always that active effort to get people involved in temporary modified or temporary alternative work whenever possible.
Right. Because usually at the employer, the people that are managing and overseeing workers' comp are different people than the staff that are managing payroll. Right. And so they should work very closely together. The closer those two positions work together, the better your workers' comp program is going to be. But I love the idea that we do a start letter in workers' comp, that the employer does a start letter about this is the start of your benefits. Usually we start communicating when you're running out of things. You're out of IA leave. You're out of all your sick leave. Oh, you're going to be out of leave and you're going on 39-month this day. We're communicating in a different way, right at the end instead of at the beginning. So.
Yeah. We need to get out in front of it rather than behind it. And again, my experience, when we're doing this, the interactive process for, now it's been 30 years there too, is that when we've adopted that kind of approach in the employers where I've set up programs for them, it truly increases employee loyalty and actually reduces absences from work. It's pretty amazing. People are so thankful about knowing their job is protected and that they're valued, and you're
setting the mindset too, right? That we're going to do everything we can to get you back to work, but also you're setting the mindset right from the beginning. I've got to get back to work. Yeah. I'm running out of my leave, right? This isn't like free time. Yes, you do have 60 days of IA leave. Most people do, not everybody. People that are covered under the Ed Code, they do. But otherwise, leave's running out, and you're also setting the expectation of your return to work program, right? You're talking about it right then from the beginning.
Yeah. When you talk about complex factors, I'm thinking about another case I recently facilitated, and the employee had been working full time at another school district, had an increase in her behavioral health problem, went into a substitute status, and has been largely working substitute. But then there were behaviors that were showing up that was like, this is not okay. And so when we did the IPM, it turns out that she had personally discontinued her treatment about a year ago, and it finally was catching up to her. And yet she was wanting, the employer to bring her back. I said, well, you know what? I said, if you're not willing to manage your own medical care and your medical situation in a way that you can be safely and consistently and productively at work, how can your employer accommodate you? And so she's been given some time now. She'd already started the process of getting back in treatment, but when you get into treatment and you've been doing that for 90 days, we'll revisit this. But for right now, we can't bring you back onto that substitute status because of the behavior we've seen consistently over the last 6 to 9 months.
Yeah, that makes me think of another example that we have at a district. It's pretty extreme, but it's along the lines of what you're saying. They could work accommodated duty, except for they have an underlying condition that's pretty serious. I think it's cancer or something. It's a pretty serious underlying condition that's a complicating factor. And they do not want to treat that. They do not want to they're not going to the doctor. They're not doing anything for that condition. So that condition is just getting worse as time goes on. But you're right. You're responsible for taking care of your health, right? For being proactive. She has health benefits. It's not that she doesn't. She has a doctor who has laid out a plan that's covered in HIPAA. This is her private doctor, but she's not going to treat it. She's in denial, right, of the whole condition. And that's how some people deal with things, right? I'll just deny it and it's not happening. But it's definitely going to have is having an impact on return to work. She could already be back to work if it wasn't for that, right? Yeah.
I had another situation recently. We're not doing a fitness for duty, but he went out for a condition, basically on a transplant list. It came up suddenly. And so he's been out for 6 months doing that. But the transplant condition actually he needed another surgery, but they couldn't do that surgery until he recovered from his transplant situation.
Mm-hmm.
And so then we met and said, well, and he's out of leave. He's out of leave like in 2 weeks. And so, well, would it be medically appropriate for you to defer this next surgery so you can get some time built back up in the books? We're not talking indefinitely, but maybe another 60 or 90 days, or at least do it over the holidays,
right.
So that you're off work anyway. And but he was in a lot of pain from that primary condition, and so he did elect to go ahead with the surgery. And so we met again, and fortunately, we were able to clarify that because these were two entirely different conditions, that he was eligible for the 100 days of education code for the second condition. Mm-hmm. And so we were able to work out, he needed more time off. His limitations were too great to safely accommodate. And it's a sort of a known surgery, so we know that the recovery is not long-term. It tends to be relatively short-term, but for right now, very significant lifting limitations until his condition has time to repair. Yeah. Now, I do want to point out a couple other, this goes back to the fitness for duty, again, in conflict situations. We had an employee who, again, was not performing her job. She thought she could go back to her bus driving job. And it was like, no, not with these limitations. And so, she thought she'd just be able to return. It's like, well, no, not with this evidence we have here. And so I encouraged her to think about it, fitness for duty. And the employer was certainly willing to do it because, because the attorney was involved too. And I said, well, yeah, you could go back to the QME. However, that's going to take probably 60 to 90 days, if not longer. And meanwhile, your paid time off is running out, and we can't put you back to work with these limitations. And so we met and we talked about IPM, and I said we can get usually set up within a 2-3 weeks max. Right. We'll have this cleared up. Well, she elected to wait and let her attorney take it back to the QME. Not working.
Mm-hmm.
Yeah.
It's a solution. It's not a good solution, and it's not a timely solution, because we have to go back and do a joint letter asking the questions, and then that's going to be on low priority, and they have 60 days to respond to those. Mm-hmm. And they usually don't even get them in the 60 days. So it's usually, I try to tell them it's 3 months usually until we even get that information. That's a long time. If you're trying to get clarity, that's not a good way to get clarity. Mm-hmm. Med legals are not a good way to get clarity, just because in the work comp system, it is a way that we get clarity, but it doesn't work so well for the period of time it is not going to be in the period of time we have to make a decision or issue the voucher. We're going to have to issue the voucher, which I'm sure in that case we did. Yeah. And because we have to offer that by law if we haven't offered a job, if we can't offer a job. And the fit for duty is faster than that, and IPM are faster than that to get clarity. They're faster, right? Primary treater, we can just give them a call. It's just hard. Doctors are busy right now. Mm-hmm. Doctors are really understaffed and overworked. And so that's low priority. That's going on the bottom of the to-do pile. Seeing patients and treating patients is going to be answering questions about letters and writing letters back. Oh my gosh, you don't even know. It's so hard. It's like pulling teeth to get responses back. Not because they don't want to, they're just too busy. And that's for them, that's not a super high priority item. Yeah.
Well, I would like to add a couple of things to that, because again, many of my participants in IPMs have heard me say this, is that treating doctors are treating doctors. They're there to treat the condition. Most doctors, unless you've been trained in occupational health, have no idea about the world of work and just what does that mean. And so I know you and I have had this conversation. EEOC at the federal level, that oversees the ADA, has encouraged employers to give the employee the right, the right and opportunity to get information. And so an employee should be able to get information within 2 weeks. Now, that might be different now because of busyness, but to give them the opportunity. And I've seen that happen several times lately. But again, a lot of doctors, treating doctors, go hands off. I'm not doing that, And so it doesn't hurt to offer it. But keep in mind that, again, treating doctors do not really understand the world of work and what it is that we're trying to accomplish. And that's where I encourage, employers, don't just, set something up. The doctor needs to be given some background information. Well, what's the issues? It's like, if I were to assess somebody, without any background information, you're leaving me to, read into a lot of it, spend a lot of time gathering information. And so the IPM helps serve that possibility, And so an IPM, like you say, is really easy to get scheduled. It's a cheaper out of all the options. And again, right there, an employer is fulfilling their obligation under state and federal law to engage the employee in the interactive process. It's like, to me, a no-brainer. Why wouldn't you do an IPM? Because you're automatically building up your defensibility. And just to claim that you've not engaged in the process, it's evident, and then use that information for the fitness for duty.
And then if we're prepared at that meeting to talk about where we are with leave and exactly what's happening with payroll, that's a great time to introduce that subject of where we are and when we're running out of leave and what is our time frame that we're working with, that we don't have 3 months to go maybe to a QME to get clarity, because we might not have time for that, right? There might be real financial hardship that's going to happen. And so it kind of gives us a better guide on the timeframes we're working with. I also get a lot of questions, interesting questions on there's more than one disability, and you see this too, when there's a non-industrial disability and there's a workers' comp. What do they get paid? Should they be on workers' comp or should they be off on sick leave? And so we always go through the but-for method. That's how we determine it. But for the cancer, could they work? If we took away the cancer and that disability, if the underlying condition is the most serious condition and it has them off, then usually they're off on sick leave. If the workers' comp condition is the condition where the doctor has them off and they can't work because of that condition anyway, then we would pay workers' comp. So, but they can't get both. So we have to make a determination. It's also like that split level. We have to determine what is the most significant disability that's causing the person not to be working, but for the other one, would they be off anyway? So it is a little tricky.
Yeah, it can be. And that's why it can be a complex process. And that's why, and again, people who participate in me as an IPM, when I get these complex situations, I oftentimes will say it usually brings a smile to the employee's face as well as others. But, it takes a village, to get an employee with a medical condition through the process, because it's complex. And there are many factors to consider. And particularly the longer a medical condition has gone on, the more being at work has been impacted. And that's a whole other topic we can talk about another time in terms of what happens, the interplay between FMLA, for example, and the interactive process and ADA and BHA. But what I want to say about something too is that, of course, I always like to research and get the facts behind stuff. And so it was a 2 or 3, maybe 4 years ago, where I did a really in-depth research project across the interplay of different laws at state and federal level. And it starts with the Department of Labor, quite frankly. The stats show that if somebody ends up being out on disability for prolonged basis or indefinitely, the quality of life, their socioeconomic status changes drastically, not only impacting the employee, but their family. And then that's what can, cause the drain on Social Security disability income and other disability benefit programs. And so the Department of Labor's goal is to keep people working. And so the other thing for an employer to keep in mind is that, again, when an employee starts running the risk of going into an unpaid status, that's where the potential for litigation again resumes. Okay? Yeah. And so that's why the earlier coordination and communication around salary, paid leave, or paid benefits like sick in the 100 days, the earlier we can do that, the more informed. Knowledge is power. Knowledge is power. And so we need to have our employees informed about that too, because until you have a medical condition, you most likely have never, ever heard of this whole process.
Well, and I really applaud the employers that are so creative with alternative work, because I really see a lot of employers trying to find temporary accommodated duty in the current department. I see that a lot. I don't see a lot of, and we're so understaffed now, kind of at all levels. Most of our employers are really struggling. We're still hiring. We're still backfilling positions. We're still lacking in subs. It just seems like more creativity with looking at alternative positions outside the department, not something they normally do, that we could have them do that would be a service to the employer, because maybe we're short, right, in that particular area. So, and we can work them temporarily out of class and out of their department and out of their supervisor and out of their site, right? So yeah, I see some really creative things going on though, but I think that should be the emphasis. If they can't work as a bus driver, there's nothing in the bus, in the transportation department for them to do. What else could they do? What else do we need, right? What do we need?
Yeah, I've seen some, like you said, I've seen some real creative application of that. Sometimes extending, the temporary alternative process just because there's a business need. And you know what? As long as there's a business need, and we're not doing anything artificial, why not? It helps everybody out, keeps them working. And I know there's one situation of where somebody was a bus driver and could not work due to a non-work related vehicular accident, but it did impact her ability to drive a bus. And it turns out that human resources really was short on staff over the summer. even though she didn't usually work during the summer as a bus driver, but they had a need. And as it turns out, she was able to develop enough skills and then also went back to school on her own. And that by the time, we really had to make a, fish or cut bait kind of decision,
Right.
Be qualified, for a new office position that she absolutely loves.
To work in that department, right? From then on, so, which was a great solution, right? Because she might have gotten a promotion at the same time and then help them fill a need. Because I said, obviously, if we can't return them in one department, but we can return them in another department, then that's a win-win, right?
Yeah. Absolutely. And, I'm moving on because I know we're running out of time here, but I did want to talk about, when emotions run high and, the ongoing use of the virtual medium for IPMs versus the in-person mediums. I know we both have had experience of where, we probably should have met online, or, no, this probably should be in person. And so I'd like to hear your thoughts, and I'll share some thoughts of mine.
So I've been to a couple in person, because now, the districts are back and some of the districts are still doing them virtual. And I can give a couple examples. We have one very, very injured employee, and we've had multiple IPMs on this particular individual, and they just get very emotional. This person's very attached to their job. And so the discussion of this is very upsetting. And the injured employee is wonderful. It's just the process is a little overwhelming. And so if he starts tearing up or getting very emotional, he can take a little break, go off camera for a little bit. We'll chat for a little bit, and then he kind of gets himself together and comes back on. If we were in person, that would just be so much different, right? So much more awkward, because there is a lot of people on this particular virtual meeting. There's like 10 or 12 individuals in his case. He has a very serious injury. Versus I went to another meeting at a district where there were attorneys there. There were 3 union reps there. It was very, very aggressive, and people ended up having to leave the room. And I thought to myself, this one would have been better virtually. This is just not going well because there's so much hostility in the room right now. We almost had to end the meeting. And I've been in a couple of those, but I thought it's too late once the time we're already in, and there were attorneys involved in that case too. So there was a lot of threatening language going on. And I thought, this would have lent itself better to a virtual IPM. This would have calmed down quite a bit had it not been in a room with this many people.
Yeah. Well, I'll add to that, Felicia, that from very early on, when we were thrust into the virtual world, and, I'm a mediator in other kinds of workplace cases and do a lot of training, that within a couple of months, people were coming back. We thought we could not do this. We had to be in person. And yet we've done it because cases aren't waiting. And time again, over the last couple of years, based on surveys, based on analytical stories in live trainings, the mediation process has been much more efficient in scheduling, less time consuming and demanding on the participants' time with a lack of travel, more cost efficient for the parties paying the tab, and managing the emotional intensity. And so we just did a survey back in August among attorney mediators throughout the country. And good 75% have planned to stay only online. A lot are doing a hybrid, and I do a hybrid. It's got to be on request. So, but the majority, I would say 80, I'd even say it's higher. 90% of the IPMs I do are still virtual. Because again, if I'm going to travel, it's going to cost more. But then anybody else, like attorneys, I had 2 last week where the attorneys were present too. That was got to be a pretty costly venture. My costs were the least of which were being,
because the attorneys are both being paid also. Well, and what I've seen too, and I don't know if you feel this works well, the employer will bring the injured employee in, and they are together, and they're zooming in, but everybody is not in the room. Right.
Or then I've seen the employee with their union representative, and that also has worked very well. Because I was asked as a psychologist earlier on, why is that so different? And I will go back to a case that preceded COVID, and I think you were there, Felicia, but there was a lot of people, some, let's say highly assertive union representatives to the point of going to the other side. And it was so intense with their language and their physical posturing and so forth. One of the school district representatives ended up breaking down in tears.
Yes. And so had to leave the meeting.
Had to leave the meeting. Yeah. And so that's one thing when we're on screen, we sort of from one of the facilitators' perspective, I can actually see people better and be able to read people's body language than if I'm sitting at the end of a long table, conference table. It's too easy for people to duck around and not be seen. But I can see that very quickly. And I can, particularly on the employee's face, what's happening. There's going to be an emotional breakdown. And so it's easier to manage, I believe, from a facilitator standpoint. The second thing is that, because we have this glass between us and the other person, we literally do not feel the emotional intensity that someone's experiencing. Think about it. If you're if you're live with somebody and somebody's getting intense, we feel it. Our bodies naturally start reacting to somebody else's emotional intensity. And so then it becomes more challenging for us to in turn manage our emotional intensity. And so this whole thing here tends to be a little bit better in terms of, and this is reported nationwide and even worldwide, that the virtual medium is actually served to help us manage the process, make it safer for people to engage. And then there's another phenomenon that's been reported is that camera's on me. I tend to show up better if I know the camera's on me. That's just another thing.
Interesting, right?
Yeah. Yeah. So I think, I think it really behooves employers, not only from a cost perspective, but is a virtual or an in-person IPM the best medium for this case? Right. And hopefully employers, have heard some of the factors that we've seen, again, across the broader mediation field, that it really has helped tremendously.
Yeah, I think the ones I've seen in U2 where they've been in person, the employee might have a disability that prevents them from really being able to do Zoom, which that's fine.
Sure.
Maybe they're not tech savvy, and so they really want to come into the district, and that some people really want to have people there, and have everybody there. But I would say it's the exception, not the rule now. I really don't see us. It's funny because I was never a fan, before. I felt like this process needed to be in person in order to be completely understood by all parties. But as with all things COVID, I adapted and I pivoted and I've changed my views. I now actually feel that it has some real positives to it, having attended a lot of both now. Yeah.
And I'll just share too, on one last note, is that what some employers have tended to do, and I know particularly for a couple of cities I work with, everybody will come into their conference room because they've been back to work in person for a long time. Right. But, I'm still virtual. And still managing the meeting. And so I've encouraged employers to think about how to, set up their room a little bit differently so it's easier to see and manage and hear. It's helped now that masking isn't required because it was challenging if people were in person and I wasn't. But again, there's all kinds of ways to slice and dice it. So it's worth having a pre-IPM conversation in how do we do this?
Right.
Yeah. So, well, Felicia, it's been delightful as always to navigate through our key areas. Again, the new EEOC guidance on COVID testing, some of those complex case factors, and again, FFD or fitness for duty can be a real help. And the earlier you start, the better in terms of avoiding some of those or mitigating some of those complex issues that may surface around leave and extended medical recovery and multiple conditions and things like that. And then too, the virtual mediums continue to prove to be a very, very positive influence on managing the emotional climate in what can be some otherwise tense situations.
Right.
Well, thank you again, Felicia. I just want to say how much I appreciate and welcome the opportunity for our ongoing engagement and conversation. As I mentioned at the outset, some links will be provided with our follow-up recording. Should be out within a couple of weeks. I'm also going to share with you, it should be published by then. I did write a rather big piece for the Disability Management Employers Coalition that they're just publishing now. And so I'll try to include that in the show notes going out. But the other thing is we're going dark in December and we'll resume in January. And who knows what the world of the legal aspects and the return to work aspects of a medical condition in the workplace will look like in January.
Yes, it was my pleasure, Deborah, and I hope everyone has a wonderful Thanksgiving.
Take care, everyone. Bye-bye.